Hello, friends. I welcome you all to this session of Indian Evidence Act, and today we will be dealing with Section 146. Section 146 states questions which are lawful in cross examination. That is, when cross examination of a witness is being done, what questions are lawful, what questions can be asked as such. Section 146 provides that besides the in addition to the questions on relevant facts, so first thing which are allowed are those questions which are on relevant fact. A witness in cross examination can be asked the following questions. What are the following questions? One is the questions which tend to test his veracity, question which tend to test his creditworthiness, that whether he is speaking true or whether he can be believed or not. Question which tends to discover who he is and what is his position in life. These are those questions which makes that whether he is a genuine witness or not, whether he is a genuine witness or he is a professional witness. And third thing is that questions which seek the credit by injuring his character. That is one which determines that of what character this person is, whether he is a person who can be believed on or not. So basically these three questions, these three types of questions which can be asked. Besides question on relevant fact, these are those questions which set up the genuineness of the witness, that whether the witness is a genuine one or not. To remember it, I have made one acronym PVC. As you can see, PVC pipe. So P is question. P is like position in life. Question which determines what is his position in life. V stands for veracity, whether he is credit worthy or not, and C, which determines his character. Now, these questions are necessary for him to answer, though it may incriminate him or expose him to penalty or forfeiture. He cannot say that he won't answer this question because it will incriminate him. So, in cross examination, besides questions on relevant fact, question testing is veracity, question testing his position in life, or his character can be asked. But provision has been substituted in Criminal Law Amendment Act 2013, through which if the in case of prosecution for an offense of rape or an attempt of rape, and the question is, so the offense is that of rape, and the question is about the consent, that whether the consent was there or not. Then, in that case, some kind of question cannot be asked. Which kind of questions cannot be asked to the victim in cross examination? Questions which would suggest that the victim is of general immoral character. So, though character questions can be asked which seek the credit of the witness by injuring his character, but in case of rape victims, it cannot be asked. Then, questions which would show her previous sexual experience, either with the victim or any other person, so as to show the consent or quality of consent. These type of questions cannot be asked in case of a rape victim. Now, Section 146 actually supplements Section 145, which we saw the yesterday, where it was the cross examination as to previous written statement. Now, testing the veracity, as we have seen, that it will check the credit worthiness of the witness, whether he can be believed or not. Questions in order to find out his position in life, like who he is, what he does, what is his source of livelihood. So, all these would set up whether he's a genuine or a professional witness. Then question can be asked like what is his relationship with the witness? Is he like is he a business friend or social friend or a family friend? so that he's how he is deposing, like, for the witness, is he influenced by some extraneous factors also, or is he speaking the truth that can be discovered? Then his feeling towards the party against whom his testimony is being given, he has hatred or he has earlier friendship. Then the third is question seeking the credit of witness by injuring his character, that is to determine his respectability, that whether his character and conduct are such that he can be trusted that he is telling the court the truth. In a case which is like called Chari versus State, AIR 1959, what it was said is that the credit of a witness can be said to have been shaken only if it can be shown that he is not a man of veracity and that he is of bad moral character. So, if it is totally shown that he cannot be uh, believed upon, then only it can be said that his credit is shaken. Like, a black marketeer is not necessarily untruthful, nor a non black marketeer necessarily means veracity. He is a means of veracity. So, in order to shake his credit, solid proof has to be given. The mere fact that answer may end to criminalize the witness is no justification to refuse the answer. So it will be no justification if he refuses that I won't answer these questions, because it will make him liable to criminal procedure, or will incriminate him. So he cannot refuse to answer on that basis. However, on what basis he can refuse is that these questions are not relevant with respect to matter in issue. So that's all with section 146, where we saw that questions besides the relevant fact, questions in cross examination can be asked regarding the position in life of the witness, the veracity of the witness, and which imputes some character or injures the character of the witness. These are to determine the creditworthiness of the witness in question. That's all for today. Thank you, friends.